Hello, this is me, Zarine. So, our today's topic is marriage registration laws in India. So, at first, I'm dealing with what is marriage, what do we mean by marriage. So, marriage is considered as a sacred institution in the Indian culture. It is a sacred bond between two people, whereby they agree to spend the rest of their lives together. There are quite a few marriage registration laws in India. So after the marriage solemnized between the bride and the groom, there are certain requirements that must be fulfilled in order to give it legal standing. Example to make it valid under the laws prevalent laws in India. So now let's see our diverse culture in India. So the Hindu Marriage Act and the Special Marriage Act. So currently there are two legislation framed to solve the challenges of marriage registration laws in diverse culture. They are the very first is the Hindu Marriage Act 1955 and the second is the Special Marriage Act 1954. The Hindu Marriage Act 1955 deals with marriage registration in case both husband and wife are Hindus, Buddhists, Jains or Sikhs or where they have converted into any of these religions. It is to be noted that Hindu Marriage Act deals with the only registration that has already been solemnized, whereas the Special Marriage Act 1954 lays down the procedure for both solemnization and registration of marriage, where either of the husband or wife or both of the not Hindu, Buddhist, Jain or Sikhs. And it is the duty of judiciary to ensure that the right of both the husband and wife are protected. In case this union between the husband and wife break, it should be determined that if this breakup was a result of action of any of the parties or not. So now let's see what is essential of marriage registration. So under the Hindu Marriage Act 1955, certain conditions must be fulfilled in order to give the marriage between the parties a legal standing and make it a valid marriage. So these conditions have been specified under Section 5 and Section 7 of Act. So by virtue of Section 5 of Hindu Marriage Act 1955, a marriage will be only valid if both the parties to the marriage are Hindus. If one of the parties to the marriage is a Christian or Muslim, the marriage will not be a valid Hindu marriage. It There was a case, the case named M. Vijay Kumari versus K. Deva Balan. In this case, a marriage between a Hindu man who converted as Christian and a Christian lady in a Hindu form is not a valid marriage. So, according to Section 5 of the marriage can be solemnized between two Hindus. And a marriage may be solemnized between any two Hindu if the following conditions are fulfilled, namely, the very first is neither party has a spouse living the time of the marriage. Neither party is incapable of giving a valid consent to it consequence of unsoundness of mind. Though capable of being a valid consent, neither of them have been suffering from mental disorder of such a kind or to such an extent. Neither of them has been subject to recurrent attacks of insanity or epilepsy. The bridegroom has completed the age of 21 years and the bride the age of 18 years at the time of marriage. The parties are not within the degree of prohibited relationship unless the custom or usage governing each of them permits of a marriage between the two. And the last one is the parties are not subtendas of each other unless the custom or usage governing each of them permits of a marriage between the two. So let's talk about the Special Marriage Act. So the Special Marriage Act deals with both solemnization of registration of marriage. Under the Special Marriage Act 1954, certain conditions have been laid down in Section 44, under Section 4, which are substantially similar to those laid down under Section 5 of the Hindu Marriage Act 1954. So as per this act, no religious ceremonies are prerequisite for the marriage to be complete. The act lays down following conditions for a marriage to be regarded as a lawful one, having legal standing by the virtue of Section 4. Neither party should have a spouse living at the time of the marriage. The physical and mental capacity of the both of the parties should be as per the section requires. The age of the parties, the male has completed the age of 21 and the female has completed the age of 18. The parties are not within the degree of prohibited relationship provided that custom governing one of the parties permits such a marriage between them.